right, good morning everyone. Welcome back, and we're happy to see you again. Yeah, I would say we will start right off with our third panel today on investment control, and we are starting with Oriana Balsamo. She's a PhD candidate in European law under a joint supervision between Luis Guido Carli and the University in Rome and Université Paris de Panthéon-Assas. And her research mostly focuses on EU economic security, foreign direct investment screening, and the constitutional balance between the internal market and national security. The floor is yours. Thanks.
Good morning, everyone. Let me thank first the conveners and the organizers of this conference, and also the speaker of today and yesterday. I hope all of you are early birds, so you like morning. So thank you also for the presentation. Today I'm here to present actually working paper that I'm doing right now, so it's a research still going on. And the title, as you can see, is the reform of the FDI screening regulation, economic security as an internal market objective. So the agenda of today is structured like this. So first I will try to make some introductory remark. Then I will look into the EU regulatory framework for FDI screening, and then the reform proposal and its two principal innovation, because as we will see, we'll have more than one innovation, but because of matter of time, I will just focus on two. And then I will look into two different aspects. The first one is the compatibility of national screening mechanisms with internal market logic. And the last one is the financial sector as a case study. And meanwhile, I will do my analysis. I will explain why I took the financial sector, and then I will finalize my analysis with several concluding remarks. So let me start with some introduction remarks. Whenever we talk to FDI, right now we still talk about Regulation 2019-452, which I know that a lot of you is familiar with. Yesterday was mentioned a lot of time. Still, I will just try to point out several features that might be helpful for the following analysis. The first thing is that the regulation was now adopted not to complete the internal market, because it's outside the logic of internal market, stricto sensu, but to discipline how the regulation from internal market works. In fact, Article 1 states that the main object is the protection of security and public order. In this sense, whenever the regulation was adopted, actually with the proposal of 2027, the main criticism was that this instrument was part of the several instruments that the Union was taking to make recourse to protectionism. Still, from the practice, we saw that actually we're talking about selective openness, mainly because we're not talking the block of all investment, but just FDI, and among all of them, just those considered risky for the security and the public order of member state and the Union as well. In particular, just to bring you some statistic from the latest one that the Commission published, we just have the 1% of blocking decision in the world Union. So we can actually claim there is a responsible selective openness, and I will focus in a moment on what type of FDI we're talking to. And as well, the latest communication of the Commission that was sent to the Council and the Parliament in December was talking about economic security tools, and the FDI regulation was included in these tools. In particular, is the joint communication 2025-977. So my research question today is whether security in its economic dimension can be seen as a new legal objective of the EU internal market. Getting into the first step of my analysis, I would like to mention, of course, the main normative focus, which is Regulation 2019-452. We're still calling as the current regulation. I will say in a moment why. And this regulation is enforced to allow member states to adopt decisions that might block, mitigate, or condition, or also authorize, of course, investment that might be risky or not for the security of their own security and, of course, of the Union as well. Still, I know you're familiar with it, but I want to underline several features. The first one is that the regulation lies on a competence dichotomy. On the one hand, there is Article 207, it was mentioned yesterday, is an Article 4 that attributes exclusive competence to the Union in common commercial policies. But on the other hand, we do have Article 4.2. In fact, the regulation itself says that the competence of the Union in this field operates without prejudice to the competence of member state in national security. So the regulation, what it does is basically like coordinating and not harmonizing the screening mechanism of the different member states. So we have significant heterogeneity across national system. Still, we do have national decision, so which means that whenever like an FDI is under investment, the final decision to block, authorize, and mitigate is national, it's from member states. It's not from the European Union, it's not from the Commission. The Commission can just adopt in the cooperation mechanism, which is not the focus of my analysis today, several opinions. In the other part, we do have, I put here a substantial formalistic approach. It's not like a weird way to say it, but actually it was part of the doctrinal debate with the Xella judgment, and it's to reply to which investment the regulation apply, which is the substantial scope. In particular, whenever we talk to FDI, right now we have, when I say right now, I say to Regulation 2019, we have a formalistic approach, meaning that those are just non-EU investors that try to, through their investment in the union, so in a union enterprise, establish a long-lasting link thanks to the investment and also because to take control and management of the enterprise that received the investment in the union. In this sense, the court in Xella adopt an approach that is like mere formalistic, meaning that we do not have the possibility to screen EU investment coming from the EU enterprises, but we do have the anti-circumvention clause, which is Article 3.6 of the current regulation, which allows the screening if the member state proves that the EU investors' aim to do this investment is to circumvent the screening mechanism, because this investment is ultimately controlled by a non-EU investors. So, the reform proposal, I didn't put here the number. It's because if the regulation 2019-452 is really clear to everybody, this regulation still does not have a number. It was just adopted the 8th of June. The Council passed the first reading before the Council, and now in the 16th of June, so just 2 days ago, was adopted. Now we have 18 months to allow member states to adopt all the different innovation. I will point out just two of them. The first one that is really important for my analysis is expansion of personal scope. We're just discussing a personal scope. So first of all, we have FDI that actually comes from EU investors, and in this sense, the one that are controlled by non-EU countries. And it's really important to see that in this case, it's not a difference between private, if the control comes from a private entity of the government, the public government, so we talk state-owned enterprises or not. And that's actually to follow, it's pretty evident, of course, it's not stated in the negotiation, that it's what the Advocate General Chapeta suggested in Xella in her conclusion. So to take into account also EU investment, because as she stated, how should we consider that an investment coming from the EU might be done with the aim to circumvent the screening if we're not even allowed to put this investment on the screening? How is that possible? The personal scope, thanks to a second legal basis, which is additional one to Article 207, is Article 114. There is a lot of debate of the stretching of the use of Article 114. Still, it is important, and I want to underline this, that Article 114 is not used to a positive integration of the internal market, but to coordinate how the restriction to internal market should operate among member states. From the material scope, we do have several new aspects. First of all, we have obligation to member states to adopt a screening. Before there was no obligation, member states can or not adopt a screening mechanism. And actually, I can say Cyprus, Croatia, and Greece, which were three last member states that adopted screening member state. For instance, Cyprus, I guess, was April 2026. As well, Bulgaria has a screening mechanism, but in terms of cooperation mechanism, is still a little bit weak. It's not out of the focus, but just to mention. So right now we have a minimum harmonization in terms of sector. They should be screened among all member states, and also we're not still talking about convergence, but we're not just talking about full harmonization, but just a convergence of national system. So let me go with the first focus on my analysis. The first one is whether the national screening mechanism today, as seen, since we do have still heterogeneity, and with the new proposal we will keep this heterogeneity in terms of like what is security for member states, whether they can block or mitigate the condition and sector, despite the one that are like common to everybody. How are those mechanisms compatible with the internal market logic? Of course, we do have a variable geometry proportionality test, and that's because first of all you have to consider which investment you are putting on the screening. Of course, if you talk about non-EU investment, then you will consider also Article 63. Whether if you talk about EU investors, in this sense, the proportionality test is more stricter. That's the golden share jurisprudence, and as well, non-EU shareholding are not considered. So it's like a substantial approach, but not fully. And you also have free movement establishment. Whether you talk about sectors, then I want to underline that before it was just in terms of defense, the screening. Now we have an expansion also to economic sector, and there is a lot of debate going on because, of course, the restriction should not come just for economic purpose. There is jurisprudence of the Court of Justice that it's really clear. But is that possible, since actually deregulation still allows the inclusion of secular sector that are also economic? There is an answer in Xella in part 66, what it says, and also from test Kleiman doctrine, that economic motives might justify restriction if they pursue an ultimate goal, that is general interest object as security in public order. The real last point on my analysis, I will not go deep because of matter of time, but that's the Unicredit BPM case. I'm pretty sure that you've been hearing this from mass media or also political discourse on it. And it's really peculiar because it's in an economic sector, and albeit non-economic in the same time, which is the financial sector, and it regards two Italian banks, but also two European banks, which means that those are banks that are already put under several supervision from different EU actors as well national actors. In this case, what happened was that bid from Unicredit to BPM, and actually the commission at first, which was the DG FISMA, no, the DG Com, sorry, authorized the bid, but then Italy intervened with Golden Power. Of course, I'm going really fast on this. But we do have several implications that I want just to point out. The first one is terminological, because right now we have a problem in terms of what does public security means in merger regulation, and if it's narrow or not to national security and public order, because of course, whenever we have an FDI that comes to a merger in financial sector, we can have a several overlap between different areas of EU law. As well, we have a procedural overlap, not just in terms of like vertical overlap, but also in terms of horizontal, because which is the competence to the DG FISMA, DG Com, DG Trade, also of course the bank, European Central Bank is authorized to do prudential supervision. So what is going on right now? There is an infringement procedure against Italy going on. Italy already intervened in normative sense, so they're trying to solve it as a procedural aspect right now, so to give precedence to European actors. I put here 3 interpretive strategies that doctrine actually suggests. And so to get back to my first question is like economic security and internal market object right now. I will respond in positive terms, so I think the Commission still wish this direction. But what is important to note that despite the presence of Article 4.2, as Advocate General Giappetta states, The mere fact that a national measure was adopted for the purpose of protecting national security cannot have the effect of rendering EU law inapplicable. In this case, we do have to consider proportionality tests as well. Thank you for your attention.
Thank you very much. Anyways, our next speaker is going to be Najibullah Zamini, and he studied law at Radboud University in the Netherlands, where he's currently also working as an assistant professor of European and international economic law. And he currently pursues his PhD there in the field of international trade law and European law. The floor is yours.
Yes, thank you. So, good morning, ladies and gentlemen. Are we naive free traders? That's a question that pops up into my mind lately quite often. And if we have to believe the former Commission President Jean-Claude Juncker, we are not naive free traders. In 2017, he mentioned in a speech that the European Union and we as Europeans are not naive free traders and that we are ready to protect our interests. Therefore, within the ambit of investments, in 2017 there was this proposal for the screening of foreign direct investments, and that concentrated on inbound investments, so investments coming from third countries. And that proposal was subsequently adopted in 2019, and it is amended now in 2026. However, nothing was said about the screening of outbound investments. So far, the outbound investments were left out. And the review of outbound investments is equally important, and that is also the core of my paper. In my paper, I have looked to the review of outbound investment screening, whereby I look to the emerging approach of the Commission, which can be seen in the European Economic Security Strategy, which was adopted in 2023. And then there was a white paper in 2024, and finally there came this Commission recommendation in 2025. And the first question is obviously, why do we need to screen or review these outbound investments, so investments made by European companies into third countries? And according to the Commission, the main rationale behind the screening of outbound investment is the fact that we have to prevent the leakage of technologies, sensitive technologies. And then I look to the approach of the Commission with regard to the screening of outbound investments, and you can find this approach in the white paper, in the European Economic Security Strategy, and in the Commission recommendation. And I look to this approach through the four classical dimensions of a law. So the first one is the personal scope. So what kind of investments, what kind of transactions are included in the review of outbound investment screening? If you look to the approach of the Commission, then you will see that the Commission says a wide range of outbound investments must be reviewed. And then the Commission provides a non-exhaustive list of transactions. And this list mainly repeats the rather well-known transactions. So it's about mergers, it is about acquisitions, asset transfers, joint ventures. So that these transactions should be reviewed according to the Commission. And then if you look to the material scope, the Commission says, well, we have only to review this type of transactions when they are undertaken in these specific three sectors. So advanced semiconductors, AI, artificial intelligence, and quantum technologies. And the reason for this is because according to the Commission, the whole reason behind screening outbound investment is to prevent the leakage of technologies. And the territorial scope of the review, as it is apparent from the documents of the Commission, that is it is a country-neutral approach. That means that a priori, member states are not required to focus on specific countries, so like China or the United States or other countries. However, the Commission in its recommendation provides the opportunity that each member state, so on a member state level, sets its priorities. So the Netherlands can, for instance, say, we will focus on these outbound investments in China, for instance. So we have some experience with ASML and Expedia in Nijmegen, while Germany might focus on other countries. So there is this possibility, but that is on member state level, not EU level. Finally, if you look to the temporal scope of the review, the Commission notes that transactions completed since the 1st of January 2021 can be reviewed, which is quite far-going. So this is the approach of the Commission, and then I look to this approach from the angle of geoeconomics. And geoeconomics is a term which is used yesterday, and I think today it will also be used again quite often. And as mentioned also yesterday, it was used by Luttwak, which means geoeconomics is the use of economic instruments to pursue these security geopolitical interests. So we see a shift whereby countries use their trade and investment policies to pursue these geopolitical and security objectives. And there are also this Blackwell and Harris, they wrote quite a nice book about this, the economic statecraft it's called, about this, and they also say it is the use of economic instruments, or like tariffs, what for instance President Trump does, to pursue this geopolitical and security interests. So this is the angle from which I looked into the approach of the Commission. And if you look to this cartoon, it is about, it's the economy stupid. Some of you may remember it. It is a phrase used by President Clinton in the 1990s when he ran for presidency. And he used this phrase to emphasize the importance of the economy. And I think nowadays it is not anymore the economy which is the most important part, but it's the politics. So it's actually, to be more precise, geopolitics. So it's all about geopolitics. And if you look to this approach of the Commission with regard to the review of outbound investments from the angle of geoeconomics, my conclusion is that the European Union is underestimating the strategic importance of outbound investments. Because the outbound investments, reviewing them, not only they prevent the technology transfers, so that the transfer of technologies or know-how, but they also reduce economic dependency. There's also something we talked yesterday about it, and it prevents building the strategic sectors of other countries. And there's actually, in China, they have this Horizon 2025 program, I think, or Made in China 2025, where they said, it is our goal, and that the strategy was published 6-7 years ago, where China outlined that their goal was to reduce the gap in technology with the West in 2025. Therefore, through these outbound investments, but also inbound investments, China tries to rebuild its strategic sectors. If you look then to the review of outbound investments in the approach of the Commission, then I think there are a couple of things which are quite disappointing, because the European Union shows it is still quite naive. And the first thing, it is a disclaimer. We have to keep in mind it is only a white paper, it is only a recommendation. So it is not a regulation, it is not a directive. Nevertheless, these documents are still important because of expectation management. So it sends a signal to other member states, it sends a signal to third countries, and they set also the bar quite low. Well, if you look then to these 4 dimensions which I discussed, the personal scope, the first thing which is apparent, it excludes these portfolio investments. So we have direct investments and portfolio investments, and the argument of the Commission is portfolio investments, they do not provide this controlling interest to the shareholders, therefore it is not necessary to review them. And I think that is quite not a good argument, because through these portfolio investments, countries can build up their strategic sectors. So capital can be used to build these strategic sectors. And that's actually also what the European Union has done. Attracting, I mean, in 2010, the European Commission published its investment policy, whereby the Commission said we want to attract these inward investments because we can build our economy with it. And another thing, a problem with the personal scope, is that the hybrid financial instruments, or like convertible bonds, are also not taken into account. So there are, at the start, they are a bond, it is but they can be turned into shares. So at the end of the day, you have again this problem with the controlling interest. So it's a bond, it is but it can be turned into equity and therefore shares. With regard to the material scope, I think the sectors are too narrow, because if you look to the material scope, it's only about advanced semiconductors, AI, and quantum technologies. And this is according to the recommendation. If you look to the white paper, in the white paper, biotechnologies was also included. But in the recommendation, the Commission dropped biotechnologies. And finally, the territorial scope. As said, the Commission adopts a country-neutral approach. So the Commission is not providing any guidance to the member states as with regard to the question which countries, so investments in which countries should be screened. Well, they also provide the opportunity to member states to make their own mind, to make up their own mind, to set their own priorities. And I think this is, again, not a good course of action, because first of all, naming and shaming is important in this regard. So if the European Commission on EU level says China is a problem, then that sends a very strong signal towards China, and it's also good for the European Union that all member states agree on that. And that's also the approach of the United States. So the United States, I looked at that a couple of years ago, have also this approach whereby they look to the countries of concern. So on federal level, they have pointed out which countries are problematic. And I know the European Union is not in a federal state like the United States. Nevertheless, I think it can be very helpful to have also this list. And there is this risk of circumvention. So if each EU member state has its own priorities, then you can imagine that EU companies can channel their investments into third countries to the more favorable destinations. And finally, the temporal scope, it leads to legal uncertainty. I mean, it's quite far if you say transactions completed on the 1st of January 2021 can still be reviewed, whereby the Commission also does not explain what are the consequences of the review. So should a merger be dissolved, the Commission does not say anything about that. Then, the conclusion, yes, in my mind, with regard to the review of outbound investment screening, we are still naive. And if the Commission adopts the current approach in a regulation or a directive, we risk to make the same mistakes as with regard to the foreign direct investment screening regulation, whereby we saw in 2019 there was no obligation for member states to screen, and now only in 2026 there is this obligation, and there was also no harmonization on EU level. And it takes also too long, and the approach is too narrow because it covers only a small number of sectors. So the ultimate conclusion is if the Commission advances on this way, we risk to repeat the same mistakes. And in my paper, I also look to the limits, and I don't know how many time I have left. We look to the limits of international economic law, which allows member states to screen outbound investments. As far as I can see, international economic law does not place any limits on it, because the GATS, that's the most important agreement, that is concerned with inbound investment screening, not outbound investment screening, because the GATS ensures market access and non-discrimination. Thank you very much.
Thank you so much for your presentation. And our last speaker of this third panel is going to be Issam Amro. He's a PhD researcher at University of Westminster, and his research mainly focuses on international disputes and the impact of economic sanction. He's also a certified lawyer in Lebanon and the UK, he engages in legal practice in the UK and the Middle East. The floor is yours.
Thank you. Good morning, everyone. So, thank you for being here on a hot Friday. I recently realized that I have something in common with the EU's economic security toolkit, is that we are both somehow slow to respond or selective in responding. And this is definitely not out of neglect, but definitely by design. In my case, for example, my response time usually depends on two main things: how important the message is to me, and who am I receiving it from. And in many ways, this is how the EU now approaches market access under its economic security framework, where formally the rule is still equal treatment. Yet in practice, the response increasingly depends on who the investor is, the sector they're investing in, and the risk attached to both the investor's nationality and the sector they aim to invest in. So my paper asks how the EU's emerging economic security toolkit is reshaping or redefining the practical operation of the most favored nation clause and non-discrimination in the EU's external economic relations. So my claim is not that the EU has abandoned MFN, and nor even that these measures are necessarily unlawful. My claim is that the baseline in which MFN operates has shifted. MFN remains formally in place, but now operates within security conditioned categories. So for the sake of time, and that to ensure I don't rush, I will begin with my findings. 4 main findings I would like you to keep in mind: security filter, MFN, sanctions, dispute settlement. Security filter is where the current framework is not a set of separate instruments operating in isolation. They could be seen as such, but each would be very technical or very limited. It is a coherent framework, a coherent system. They create a layered system with a cumulative effect. Each instrument on its own is somehow technical or limited, but together are reshaping the market access environment. Second finding, MFN. MFN is formally unaffected. It remains intact. Where in classical trade and investment law we all studied, we learned that MFN's logic is that like situations are treated alike, with availability of narrow exceptions based on public order and security. In today's EU context, these exceptions are no longer narrow. They are transforming into the logic on how market access is actually structured. Third finding, sanctions. And this means to me for 2 reasons. One is that a huge part of my actual PhD research is on sanctions, and I needed some extra research. Second part is that it is now actually occupies a deeper influence. Sanctions generally matter nowadays, as we are witnessing unprecedented waves of sanctions, not just from the EU against Russia, from the US, and every other entity or country which has the power to sanction. But in particular, secondary sanctions and extraterritorial measures establish different legal environments for different investors. We can even categorize this as a pre-screening phase, where sanctions risk becomes part of the benchmark problem at the center of MFN. Third finding, dispute settlement. It is a major doctrinal shift, which requires proper naming. This shift should not be treated as a byproduct of the economic security toolkit. It should be recognized explicitly both in doctrine and in dispute settlement. So, a bit of data. The current EU screening environment shows that there are around 3,100 screening cases in 2024. 92% cleared within 2 weeks, and a rise in notifications since 2021. So apparently the 92% is not slow. It's the whole framework that is. At the same time, 3 member states still do not have screening systems in place. However, as my former colleague spoke, now the new regulation in place will shift into a mandate of establishing screening mechanisms. A significant portion of FDI stock still passes through jurisdictions without fully operational screening framework. So what does this actually mean? is that the issue is how screening operates, not if it exists, because it clearly does. The system is uneven across member states, so it creates differentiated entry conditions. I named the security filter as my first finding. So what do I mean by that? It is a concept that indicates a structural transformation is underway. Investors no longer approach a neutral legal field and then encounter occasional exceptions. They come in with they approach an increasingly risky field or a field that's pre-structured by risk. And I look at this in 3 layers. FDI screening being the first layer, with criterion such as sector sensitivity, state influence, corporate structure or the ownership structure, and public order. And as you can see, nationality is not mentioned explicitly, but you can read it between the lines. Second layer is sanctions and extraterritoriality. Some investors arrive with risk on their shoulders, with a banner on their forehead that says, "I'm risky." Evaluation at this point happens differently. It's not just treated as an inward capital, it is rather treated as inward risk-bearing capital. The third layer is the anti-coercion instrument and tools. Anti-coercion instrument is important because it makes the geopolitical dimension explicit. It shows that the EU is no longer reacting to direct market threats. It's no longer reacting to the direct threat, but it reacts to the strategic pressure which is being influenced on the EU itself from third countries. And it got me smiling because when I was preparing for this, it was the beginning of the World Cup. So it's somehow like how coaches shift the game from direct pressure, from direct threat to general pressure and scoring a last-minute goal. You move from defense to offense in one way or another. So what is the doctrinal point behind all of this? MFN is a comparator principle. So to determine if there is or if there has been less favorable treatment, we need to know what we're basing this treatment on. So who counts as being like situation? And that's where all the change is being done. My argument is that the EU's economic security turn is rewriting the answer itself. The field of comparison is now narrowing down. It's narrowing down into some investors are just non-comparable by nature due to the strategic risk they hold, the technological risk they hold, and the geopolitical risk they hold. And the result is not that the EU is abandoning MFN again, but rather re-anchoring it with differentiated risk categories. So based on all of this, my hypothesis is that the EU's shift towards risk-based economic security governance should be understood as a deliberate move towards security-conditioned categories of market access for third countries, capital and trade. In that model, MFN and non-discrimination are re-anchored within differentiated risk tiers rather than a presumably uniform and open market for everyone. Even if this remains formally compatible with the existing law, it still represents a substantive readjustment, a substantive shift that requires naming. So, now that I've established my findings and my claim, my argument, a bit of research and methodology to explain. This paper, first of all, sits at an intersection of 3 different conversations. They are often kept apart. The first is the literature on MFN and non-discrimination in trade and investment law. The second is the expanding literature over the past few years on the EU's economic security, strategic autonomy, and FDI screening. So on one hand, we have MFN and investment law. On the other hand, we have FDI screening and EU's economic security. And on the other hand, third is the literature on sanctions, coercion, and geo-economic governance. So my contribution is to bring these together and to argue that the transformation of MFN cannot be understood by looking at one of them in isolation without the other. So methodologically, the paper combines doctrinal legal analysis with a political economy reading on judgments on the EU's geo-economic approach. On the doctrinal side, it examines the EU's primary and secondary law relating to FDI screening, outbound investment control, and the coercion instruments. On the political economy side, it asks how ideas such as risk, dependency, reliance, strategic rivalry are being translated into legal categories. Because I was once told by my PhD supervisor that whenever a debate is political, the flip side of the coin is a legal question. So, back to dispute settlement, which was my fourth finding. No forum is seeing the whole transformation I am talking about. Not that I'm smarter than them, but the thing is that the WTO panels will increasingly be asked to assess whether security-based differentiation fits within the exceptions, the existing exceptions. The EU law asks internal questions of competence, institutional balance, proportionality, which is key in many cases, even as the one mentioned in the Xella judgment. Investment arbitration, tribunals will face claims involving differential treatment, legitimate expectations, and the invocation of essential security interests. So to conclude, economic security turn is instituting a new organizing logic for external economic policy. MFN has not vanished, it just operates in a different environment. Security-defined filters at the level of FDI entry, sanctions risk, strategic dependency, and related trade instruments are established as filters. So the consequence is a move from equal treatment across a uniform market to equal treatment within differentiated risk categories. And I finally say, this shift should be named. It should be named and addressed directly, rather than left to appear as a technical side effect or byproduct of the economic security governance. Thank you so much.
Thank you very much. And now we're looking forward for the comment by Professor Dr. Wolfgang Weiss. He holds the chair for public law, EU law, and international public law at the University of Administrative Sciences, Speyer, and his expertise ranges from public law and EU law over public international law with a special emphasis on German and European economic, constitutional and administrative law, as well as WTO and UN law. Thank you very much.
Thank you all for welcoming me here. Yes, we had 3 excellent presentations based on a well-elaborated paper, so I can keep my comments brief and short, but I will try to maybe raise some question marks to some of the hypotheses which were presented here, at least to challenge some of the basic premises. So with regards to the first paper, economic security becoming a topic or an objective of internal market. Yes, of course, the findings of your research was that this is the case, we see it. And that's actually not maybe the first one, the first example of foreign direct investment. I was wondering when I read the paper whether we do not have a forerunner in the defense procurement sector. Well, that is very peculiar. In Article 346 of the Treaty on Functioning of the European Union, you also have this carve-out that trading with ammunition and arms and weapons is, of course, an essential security interest, which is solely in the realm of the member states. And still, the European Union, in order to conceptualize and establish sometime a kind of common procurement market for defense goods, adopted a defense procurement directive in 2009 even. And of course we see even here that even though we have this carve out already there at that time. The Court of Justice, which later had to deal with this directive, said that this is not a complete carve out of European Union law, and it is still possible for the EU to somehow coordinate or even harmonize certain basic requirements of defense procurement within the member states. So we have some forerunner of this where we can see, okay, security, well, not only economic security, but even defense security, so the much more classical term, is part of our internal market law. Already then. So this discussion might be helpful for you as a comparative element in your paper and in your research. So even then, this procurement directive was based on what is now 114. At that time, in 2009, it was still Article 95, I guess. So this competence of the EU was already used and exploited at that time to establish and enact this new EU legislative instrument, which we could say now. Some more comments on specific aspects. Of course, we have the challenge how to bring together these different screening mechanisms. If you have a foreign direct investment, the investor might fall under merger regulation, under foreign direct investment control, and also maybe under foreign subsidies review. So 3 review procedures at the same time. I don't think that we should try to harmonize the benchmarks in a coherent manner, because all these 3 instruments have a different focus. The one is on competition in the internal market, the other one is on subsidies, and foreign direct investment is about security issue and sensitive infrastructures. So, but what we need, and here I fully agree with you, at least that is a minimum requirement, that we need a procedural coordination, of course. That is necessary for the investors, maybe something like a one-stop shop so that they know who is responsible, because there are different DGs, of course, involved in scrutinizing then a foreign direct investment under these 3 different instruments. Let me now switch to Nachibula's analysis of the outbound investment and what is at stake there. Well, yes, of course. You coined this phrase, it's the stupid, no longer it's the economy stupid. Well, it's the politics. Yeah, well, both come together now in this area which we are discussing today and even yesterday, both come together because behind geoeconomics, of course, stands the attempt and the pursuit of states to use economic instruments. Tariffs, of course, is the most prevalent one in the US administration, to use such economic instruments for industrial policy purposes, but in the end, it should serve the domestic economy, bring new labor force, bring reinvestment into domestic industries. So expand the export capacity of the US economy. So in the end, it's again about economy, but this time the states no longer trust into economic efficiency and the good work by the companies and the better productivity of their companies, but they trust in politics accompanying economic logics. One of the criticisms you raised was the scope of application with regards to ratione materiae, which sectors should be covered. Yes, you're right. It does not fully, it does not reflect the scope which we have in the foreign direct investment regulation. What the Commission currently plans, but it's only a very professional consideration because we do not have a legal proposal, is less. Yes, so one could think whether this is this does justice to strategic autonomy. Well, I was thinking Should we really have a parallel scope of application? Might we not be careful to avoid overreach? Because the question which came into my mind is, do we really have a win if we restrain our EU companies too forcefully from going abroad? There are issues in technology where the EU is behind. For example, artificial intelligence. So as a EU company, if you want to contribute to cutting-edge research in that area, maybe it is necessary that you also invest your money abroad, in China, in the US. That, of course, brings problems, but that's why I say, well, outbound investment control must be carefully drafted. If we cut off our companies from the chance to take part in technological developments in other countries, that might not pay, well, it might not pay off for the EU. So I'm a little bit more cautious to be overly restrictive. Can we really afford to limit investment in China or America and so constrain our business from doing research abroad, which might be more useful, maybe? Finally, a word about the international legal frame. When we look to foreign direct investment, then of course it's the GATS which might be affected, because we have this mode 3 establishing a legal representative in another country which falls under mode 3, but of course MFN applies irrespective of the specific commitments which states entered into under the GATS. But still, the question is, of course, do we see a breach of MFN? Well, Islam, you said formally we do not, and I will comply with that finding. But the question is then, of course, and you raised that very succinctly, whether we still see some change. And of course, other papers speak about the securitization of trade and trade relations, and really we can see, also learning from the discussions yesterday and today, that economic security has brought about a change in the way how we think about international relations, and that economic security brought about a new objective or a new tool or a new thinking, maybe a new thinking is a better word to frame it, a new thinking about how we can establish and shape trade relations. And so it's actually not the transformation of an MFN. In your chapter 4, your title was Transformation of MFN from Residual Exception to Organizing Logic. Well, it's not the MFN which has been transformed, but it's actually the way how to use security. It's no longer used as a exception which may be invoked very rarely. That was, of course, the understanding in past time. Now we find it everywhere, all over. It's now a shaping logic for international economic law, for international trade relations. And you're right that you say, well, that is somehow has turned into a security filter, a new lens under which states look at their trade relations. So I agree with your finding insofar, but would challenge you to reconceptualize it a little bit, as it's not really a transformation of MFM, I think. Probably we can say, well, if there is a breach of MFN, we can try to justify it under the security exceptions you also find in GATS, but that's the question, of course, could also be placed whether securitization becomes a logic within the aspect of likeness. Do we have like services if we have different feelings about security? So then, of course, we have a little bit of a transformation of the MFN as well, as we could consider issues of security also within applying MFN. And well, that is formally it's a way which the appellate body denied in the ECLC's case, only allowed that under the TPT agreement, not under the GATT, but the appellate body did not speak about GATTs. But that is, of course, a way where we could say, okay, it affects also MFN and how we apply MFN if we, even on the basis of the wording of Article 2 GATTs on MFN, we consider security issues. And then, of course, it would be relevant, where can we do this? Under likeness, maybe, under favorable treatment standards. Well, I have no idea about that, no fixed conclusion which I can present you. I only raise a question mark. Thank you so much.
Thank you very much. You have a first question?
Thank you very much for the very interesting panel. So I have a question, more of a additional comment for Isam, because I had this exact same thoughts like Professor Weiss, because in what you seem to argue, it's not really like a transformation of MFN, but rather a broad interpretation of the exception. Unless you want to include the security as an interpretation of like services or like services suppliers. And this actually led me to think about an argument that James Flett made in 2022 in a European Commission publication dedicated to 70 years of EU law. In that case, it was a bit different. It was with respect to MFN and in relationship to the CBAM, saying that considerations with respect to climate should be taken into consideration in the context of likeness, because it doesn't make sense to always have a violation and only subsequently trying to justify it under Article 20. So potentially for you, it would be useful to make a similar argument with respect to GATT's MFN and the security exception, saying that maybe we shouldn't solve all the disputes at the level of the exception, but trying to resolve it at the likeness step. Of course, as Professor Weiss said, there is no currently jurisprudence that would support that. But you could at least try to make your own argument, like a similar argument as James said, the Deputy Director of EU Legal Service tried to make. Of course, this is more convenient for countries like the EU because then you avoid very strict conditions of the justification. Yeah, thank you.
All right, would you like to respond?
Thank you, Professor, and thank you for the remark again. The thing is, by transformation of MFN, what I mean, and as I explained it during the presentation, is that the shift is becoming from, the baseline shift is turning from the principle to the exception, where we are not starting from the principle of equality and non-discrimination and then invoking the exceptions. We're starting, it's like when you're solving an MCQ question or a problem and you do not know the answers, or you have a 50-50 chance. What you do is you go by elimination. So that's how I view the EU is approaching its obligation of MFN, is that the elimination process is happening through the security exceptions and the public order exceptions. So we're eliminating first, and whatever is left is treated as like situations, and to some extent. Because we're invoking, this transformation is happening by invoking the security exceptions first, by invoking the public order exceptions first, and then the principle of like situations is being... It's changing, this is inevitable. This is inevitable. Due to the economic security toolkit and due to the screening mechanisms and due to all the instruments, the shift is transforming in one way or another. Yes, but the thing is, proportionality is a key question, and good faith is another key question. So these are always ambiguous and vague exceptions. The thing with legal exceptions based on security and public order are left vague and broad, and it's what you said, that we can consider it as a broader interpretation of the exception rather than a transformation. But as this exception becomes broader and broader, it becomes the baseline, it becomes the threshold, because the key usually is for the baseline to be broad and the exceptions to be narrow, and not the other way around.
That's exactly what James says, and that's why he suggests to shift it to article, like to the MFM, not to become the exception that it is always seems violated and
Okay.
always rejected, right?
All right. Any other questions? Yes.
Thank you. So I have a comment on Najib's presentation. Your criticism or skepticism towards the country neutrality of outbound investment screening really resonated with me, because you have the same phenomenon also with inbound investment screening. You don't have any lists of countries that are countries of concern, such as in the US. And I always thought that this is a little bit phony, because I think state regulators and the European Commission do know exactly which investments from which countries they want to screen thoroughly and which ones they are not really screening thoroughly. And I think this leads to a lack of information representation in the law, and I think it would be better from a sort of legal precision point of view to actually put the exact countries. It doesn't have to be a sort of a complete list, but at least the countries that are particularly problematic. I do understand also from a diplomatic point of view why you don't want to do that, but I think legally it's a problem. And also that brings me to the second point that is kind of tied with that, and it relates at least a little bit to Oriana's presentation, because you still have the old test that was developed for investment screening that was developed by the European Court of Justice, and the genuine and serious threat to a fundamental risk of society test, and which is certainly going to be applicable to investment screening as it relates to investments within the European Union. I think the jury is still out on the question on whether it's also going to be applicable to investments that come from companies from outside the European Union. I think that's contested and not finally decided yet. But I think that's also kind of a test that was developed, especially in the golden shares jurisdiction by the European Court of Justice, some 30 years ago, is really applicable to different situations. And of course you can subsume the current geo-economic problems under this test, but I don't think it gives you a lot of guidance on how you're going to decide the case, and so I think the criterion is not very helpful. Thank you.
Thanks.
Yes, thank you. Good point indeed raised. My argument to mention the countries by name is actually twofold or threefold. First of all, that is more not really a legal argument, but more a diplomatic argument, meaning it put pressure on these countries. So if you mention the United States, or if you mention China specifically on EU level, then these countries hopefully will get the message without the consideration, because sometimes I have this feeling that Russia or China have the idea that the European Union is divided, that the member states cannot agree. And we saw that actually also with the previous government in Hungary. Right, so Hungary and Russia was using that quite well. So that's the first thing. You send a quite strong signal. And the second thing is it provides guidance to the member states. And thirdly, and I think it is will also lead to legal certainty, because investors in companies investing in those countries know a priori beforehand that this transaction can be reviewed. So they can take that into account in drafting all these contracts and all these issues. From a legal perspective, whether it's problematic, to be honest, I don't know. Maybe the only thing could be that you come into conflict with the MFN principle, but again, I'm not sure, because you are treating some of the countries differently. Again, that problem will not be big, because screening outbound investments does not fall under the current framework of the WTO. I mean, if it is about inbound screening, then I get the message that you cannot say we will focus on China. And I think that's also one of the reasons that in the current FDI screening regulation, or in the new one, no specific countries are mentioned. Because then you will infringe market access and the non-discrimination, all these principles. With outbound investment screening, at least from an international economic law perspective, you have no limits and no legal problems, therefore you can mention it. I think, and that will have some good benefits in my mind.
All right. Any other comments? Or
Thank you for your comments, also to Professor. I don't think I understood correctly your point. Is it like a criticism that you have? Like, because you mentioned the Xella case, the proportionality golden shares, like there is a lot of stuff. So I just, in order to reply, is there more like in how we should use proportionality test still, or if it's...
No, it was more a general point, I would say, and it was more related really to, was it an extension of the point I made to Najib's case, the point of legal precision, right? So on the one hand, legal certainty, we're not mentioning what countries we really want to do the investments from, and then secondly, we use the old dogmatic category of genuine and serious threat to the fundamental risk of society test developed by the European Court of Justice for a very different time, very different cases, and now we're extending it to new cases, and I think it doesn't give us a lot of guidance how to decide those cases. So that was really an additional point.
Okay. No. I will catch up with what you said, just to make clear, because I know like a lot of you are aware of Xella, but to catch up on what you say, it has been a discussion, of course, in doctrine, because the Xella judgment was the only judgment that we have on the regulation, but the court decided to analyze it from a different perspective, analyzing the internal market. That's why my analysis from the jurisprudential is still sticked to the internal market, but because, as you say, like it should be, and it's actually a point that I think that is still good, but still I understood what you say. I mean, like taking more like the current context and not strictly related to criteria that were established with the geopolitical world was different. But in this sense, in positive terms, I can claim, just like Advocate General Xella, when she said actually if this question was asked, so the expansion to FDI to target the U target 10 years ago, she will say no, of course, because of principle of discrimination, but today she will say yes. And I mean, just to take for the target, the new regulation actually talks about, in Italian is impresa figlia, in English will be the U target, so those are under screening right now. Plus, we do have the possibility to have greenfield, as you know. So I think somehow they're trying to consider this changing that we need. Thank you.
Thank you very much. So now any other questions or comments? Anyone from you who would like to add something? Well, I mean, if there's like no urgent questions, then we can also dive in our coffee break. And now I would say we'll meet back at 10:30. Yeah. All right. aspects of the digital era, and we're starting off with a presentation by Lino Monaretto. And yeah, Lino studied law at the University of Göttingen and completed his legal clerkship at the Higher Regional Court of Frankfurt am Main, and currently serves as legal counsel in the Directorate General Legal Services of the Deutsche Bundesbank. So we're looking forward for your presentation.
Thank you very much for the introduction. Before I start, just let me clarify that despite of my professional affiliation with Deutsche Bundesbank, the views and opinions I will present are only my own and do not necessarily reflect those of Deutsche Bundesbank. That disclaimer is important because I'd like to talk to you about legal aspects of digital central bank currencies, CBDC, and monetary sovereignty today. As you might have heard, the European Central Bank is preparing to issue a digital euro. And some of you might ask, why are they doing this? Do we need this? You are not alone. The digital euro has often been described as a solution searching for a problem. So why should we be interested in this question as lawyers? Well, the success of the digital euro does not only depend on the willingness and readiness of citizens to use it. The EU legislator intends to impose several obligations on private actors, including banks, payment service providers, and merchants. The legislator is doing that to ensure that the digital euro will be available and accepted. The proposed digital euro regulation may affect the rights of private market actors, in particular their freedom to conduct a business. Each state intervention interfering with fundamental rights requires justification. If the digital euro was a solution without a problem, interferences with fundamental rights could hardly be justified. One day, courts might have to decide on these matters, and for that reason, we should be ready to answer whether the digital euro and its design is justifiable under EU primary law. So, let us start by looking for the rationale for introducing the digital euro. All EU institutions present the digital euro primarily as contribution to the EU's strategic autonomy and its monetary sovereignty. The concept of strategic autonomy is part of the EU's reaction to geopolitical threats. It expresses the EU's ambition to remain open to international cooperation while being able to act autonomously where necessary. Monetary sovereignty is a manifestation of strategic autonomy in the field of money. In legal terms, monetary sovereignty can be understood as an entitlement and capacity of a state to regulate its own currency. It includes the power to issue the currency, to control its value, and to lay down rules governing its acceptance and use. In the euro area, monetary sovereignty has been transferred to the EU. But what exactly are the threats to monetary sovereignty that the digital euro should address? First, the digital euro is supposed to prevent a phenomenon called dollarization. This would occur if payments in the euro area were not settled in euro anymore, but in privately issued stablecoins denominated in foreign currencies, such as the US dollar. Second, the digital euro is meant to reduce dependence on foreign payment service providers like Visa, MasterCard, or PayPal. Recent events have demonstrated how easy we can be cut off from important infrastructures that we have relied on for quite a long time. ICC judges being subject to US sanctions were banned from using their US credit cards. And this month, the US administration banned foreigners from using AI tools provided by the US firm Anthropic. These cases reveal access to money can be weaponized by those who have the authority and power to control it. Against this backdrop, safeguarding monetary sovereignty against such threats seems to be a legitimate aim of EU action. However, strategic autonomy and monetary sovereignty cannot operate as blanket formulas that simply override economic freedoms. They must be assessed under the legal framework of the treaties, including the Charter of Fundamental Rights. This is why I'd like to take a closer look with you on the following aspects. Does the digital euro, backed by far-reaching obligations on banks and other private market actors, comply with EU primary law? Can strategic autonomy and monetary sovereignty justify interferences with individual economic rights? And if so, under what conditions? I will focus on a review of the right enshrined in Article 16 of the Charter of Fundamental Rights, the freedom to conduct a business. But before I come to this point, I'd like to say a few words about the general constitution of money in the EU. How does our monetary system work? What kind of monetary constitution is enshrined in the treaties? And how does it distribute monetary authority between the state and the market? The EU monetary system rests on a division of labor between state and market actors. Public money is issued by the Eurosystem central banks as cash and central bank deposits. Private money is created by commercial banks when they grant loans and thereby create deposits in customers' accounts. We can imagine this system as a pyramid, with public money at the top and private money at the bottom. This two-layer system works as long as public and private money remain fully fungible. Fungibility means that private money held in bank accounts can be converted into cash as public money at par. Due to fungibility, we don't recognize the difference between cash and electronic payments in our daily life. €1 is €1. This is a short story of the hybrid nature of our money. The hybrid architecture of the monetary system is backed by the monetary constitution enshrined in the EU treaties. The EU monetary constitution allocates monetary authority between state and market actors. We can thus call it a hybrid monetary constitution. On the public side, this constitution grants powers to the EU legislator and the ECB in Article 127 and the following articles of the TFEU. The legislator is authorized to regulate the use of the currency, for instance, its legal tender status, while the ECB is empowered to maintain price stability, issue cash, and safeguard the functioning of payment systems. On the private side, private banking activities are covered by the freedom to conduct a business, enshrined in Article 16 CFR, and the principle of an open market economy with free competition laid down in Article 119 and 127 TFEU implies that the allocation of financial resources shall be broadly left to the market. Now we can understand the highly political impact of the digital euro. A central bank digital currency has transformative potential. It could shift monetary authority from private banks to the central bank, from market to state. The ECB, however, insists that the digital euro is not meant to disrupt the hybrid monetary system, but to stabilize it. And the legislator has chosen a conservative design for the digital euro. This approach might not be merely politically chosen. Both the EU legislator and the ECB are bound by the hybrid monetary constitution. I will now focus on the question whether the digital euro complies with the freedom to conduct a business as one element of the hybrid monetary constitution. The freedom to conduct a business under Article 16 CFR protects economic initiative and the ability to participate in a market. It covers, in particular, the freedom of contract and free competition. Banking activities fall within the scope of this right. The digital euro regulation and its implementation may interfere with the freedom to conduct a business in three main ways. First, it may create displacement effects because under the proposed regulation, the digital euro would be a direct liability of the Eurosystem central banks. It would be recorded on the central bank balance sheets, not on the balance sheets of the credit institutions. Although digital euros may also be acquired in exchange for cash, funding will generally come from existing deposits at commercial banks. Private money recorded on commercial bank balance sheets would therefore be replaced by public money recorded on central bank balance sheets. Consequently, credit institutions will lose part of their deposit business. Second, the digital euro imposes financial burdens on financial market actors. Credit institutions must offer basic digital euro services upon request, and all payment service providers must provide basic digital euro services free of charge to end users. Their fees vis-à-vis merchants and other payment service providers are kept. These obligations and restrictions affect the freedom of contract. Providers are not fully free to decide which services to offer, whom to serve, or what price to charge. They may also have to bear implementation costs. Third, the digital euro may create competitive disadvantages. The legislator intends to confer legal tender status on the digital euro. Merchants would generally be obliged to accept it. Combined with free basic services, this gives the digital euro competitive advantages over private payment solutions, especially those that do not benefit from mandatory acceptance. Established providers may adapt, but innovative providers may face market entry barriers. Taken together, these effects amount to limitations of the freedom to conduct a business under Article 16. The final question is whether these limitations can be justified. Article 16 CFR is not absolute. The European Court of Justice repeatedly emphasizes that the freedom to conduct a business must be viewed in relation to its social function. Nevertheless, any limitation must satisfy Article 52 CFR. It must be provided for by law, pursue a legitimate aim, be suitable and necessary, and strike a fair balance between the general interest and the right affected. The provided for by law requirement is fulfilled, since the limitations will be laid down in the digital euro regulation. As to the legitimate aim, preserving monetary sovereignty qualifies as an objective of general interest. The European Court of Justice generally allows the legislator a broad margin in defining matters of general interest. In a recent decision of October last year, the President of the General Court has explicitly recognized that the digital euro project contributes to strengthening the strategic autonomy and monetary sovereignty of the euro area, thereby fulfilling an objective of public interest. The suitability test is also likely to be met. There is no precedent for a central bank digital currency of this kind, and it remains uncertain whether the digital euro will strengthen monetary sovereignty in practice. But under conditions of factual uncertainty, public authorities enjoy broad discretion. The argument that a publicly backed digital payment solution could make the EU more independent and resilient is at least plausible and not manifestly incorrect. What about the necessity of the limitations? The EU has already taken measures to address threats to monetary sovereignty. MiCA, the Markets in Crypto Assets Regulation, regulates stablecoins and imposes safeguards against crypto assets denominated in foreign currencies. Others suggest that a wholesale CBDC, meaning a central bank digital currency only for interbank payments, may be sufficient to preserve monetary sovereignty. However, these measures do not necessarily rule out the need for the retail digital euro that is supposed to be available to the broad public for everyday use. The retail digital euro responds to a different risk scenario, the possibility that the EU could be cut off from foreign payment systems. The example presented in my introduction show that state influence over private payment infrastructures can be weaponized geopolitically. As long as domestic operators have not established a pan-European payment system, there is a strong case for the ECB to ensure that an alternative infrastructure remains available for everyday payments. Given geopolitical uncertainty, the assessment that a digital euro is necessary cannot be regarded as manifestly unfounded. Finally, the measures must strike a fair balance. The more intense the restriction of economic freedom, the more important the interest in safeguarding monetary sovereignty must be. Several factors support proportionality. Most important, the regulation contains mitigating and compensatory mechanisms. Holding limits are intended to prevent large-scale transfers from commercial bank deposits into digital euro wallets. thereby protecting banks from displacement. And the compensation model allows payment service providers to charge merchant and other providers fees for their services. Finally, the essence of the right is respected in accordance with Article 52 CFR. A violation of the essence could arise if the digital euro prevented certain banking activities from being carried out as such. But because of holding limits and compensatory measures, credit institutions do not have to fear that their business models will be fully displaced by the digital euro. Nevertheless, the legislator and the ECB are required to review their measures to ensure their proportionality in the future. Article 41 of the Digital Euro Regulation expressly provides for such review. Measures initially necessary to introduce the digital euro may later need to be adjusted. Let me conclude. The digital euro is part of the Union's response to geopolitical tensions. It is designed to strengthen strategic autonomy by preserving monetary sovereignty. At the same time, the digital euro will burden private market actors. It may create displacement effects, impose financial costs, and affect competition. These burdens amount to limitations of the freedom to conduct a business. My central claim is that these limitations are, in principle, legally justifiable. Monetary sovereignty can constitute a legitimate aim of general interest. The threats to monetary sovereignty are the problem that the digital euro could solve. The digital euro is suitable and necessary to pursue that goal. The current regulatory design, especially holding limits, the compensation model, and the duty to review, also ensure that a fair balance is struck. However, monetary sovereignty cannot serve as a blanket formula for overriding economic freedoms. The EU legislator and the ECB must give reasons and review their assumptions. And they will have to adapt the regulation and its implementation if risks diminish or burdens become excessive. The legal design of the digital euro therefore complies with Article 16 CFR because it remains embedded in the boundaries of the EU's hybrid monetary constitution. A constitution that neither leaves money entirely to the market nor places it entirely under unrestricted public authority. Thank you very much.
Thank you very much for your presentation. Our second speaker is Esther Ausalenden-Adu, and she's a PhD researcher at the Leuven Center for Global Governance Studies and Institute for International Law at KU Leuven. And she's also a research associate at the America-Europe Fund's Chair on Technology, Innovation and International Regulation. Her research mostly focuses on the legal implications of unilateral supply chain regulations from a WTO law perspective. So the floor is yours.
Thank you. Good morning, all. Firstly, I'd like to thank the conveners of YELS for bringing together such a stellar group of scholars across the international economic law discipline. I truly look forward to subsequent discussions with learned colleagues here today. So, as already mentioned in my bio, my research focuses a lot on the intersection of innovation, regulation, and technology and international regulation. So it comes at no surprise that my paper focuses on supply chain regulation being at the center of the chip war, which I consider to be the new tool of choice in an era of techno-economic competition. And the background to this paper is actually twofold. Firstly, it was mainly derived from my concurrent research, which I'm currently undertaking under my doctoral project, which centrally tries to figure out the legal implications of unilateral trade-related measures that target critical global value chains, especially from a trade law perspective. Crucially, my project proposes the integration of concepts and frameworks from value chain scholarship into the legal analysis of a category of trade-related measures which I class as supply chain instruments. So in my paper, I already provided a preliminary framework where I kind of view these instruments as a category of semi- and fully autonomous instruments that condition market access, so you have that prescriptive element, in the enforcement of non-economic objectives along key nodes of critical global value chains. As I contend that the proliferation and essentially the creation of these global value chains are intrinsically connected to the origin story of our present global trade law system. For example, at the turn of the century, while these GVCs were in their earnest beginnings, that also coincided with the founding of the WTO, and of course the consolidation of key provisions within the GATT, for example, the permissibility of members creating these preferential trade agreements with the goal of further regionalizing the gains of multilateral trade liberalization. As such, considering the present exogenous factors from persistent trade and tariff wars, the waning influence of the WTO, and the proliferation of broad-based industrial policies across both advanced and emerging economies, which are essentially fracturing the global trade systems, nation-states are increasingly designing their interventions to mirror the structural dynamics of value-added trade. So I briefly provided some key definitions regarding these concepts, because especially from the eyes of trade law scholars, these are quite new and technical concepts. So for example, global value chains essentially consist of the full range of activities firms, farmers, and workers kind of carry out to bring a product to the market from its conception to end use. So it really covers the whole range of activities and stages of the production process from end to end. So we've essentially turned into a global economic trade system where we used to be operating under the trade of finished goods. Now our global trade system consists of the trade of intermediate goods, known as value-added trade. So to exemplify the saliency of this integrated law GVC approach in the legal analysis of these trade-related measures, I designed a case study which sits at the heart of the present techno-economic competition, which is the global semiconductor supply chain, literally the backbone of the concurrent twin transitions, whether in tech, for example, AI, AGI, and of course, green energy. To kind of exemplify the saliency of this integrated approach. So in applying GVC methodologies, I mapped out the global semiconductor value chain and focus in particular on the EU and US's policy interventions as contained in their respective CHIPS Act. Because at the time of the writing, at the time when I was writing and drafting this paper, both markets represented about 62% of the global semiconductor value chain. So as you can clearly see from the distribution of the key nodes of the global semiconductor value chain, the EU and US have capabilities, for example, in the upstream of the value chain, whether in R&D, design, even manufacturing equipment. But when it comes to materials, fabrication, assembly, testing, and packaging, that is mainly the domain now in East Asian markets. So, as part of this exercise in elucidating the saliency of this integrated law GVC approach, my research resultant legal analysis was guided by three main questions. Firstly, whether the selected instruments are supply chain instruments, because within the academic literature, they still treat them as part and parcel of industrial policy. So this is basically where I begin to test my framework of whether these respective CHIPS Acts could be classed as a category of semi or fully autonomous instruments that condition market access in the enforcement of non-economic objectives. In other words, are these supply chain instruments? The second question then looks at whether the selected instrument exhibit this whole of supply chain approach, which covers these critical GVCs end to end, rather than only address the respective states' vulnerabilities. Recall, for example, the slide that I showed, the previous slide on the mapping out to the global semiconductor value chain. It is very clear that the EU and US have certain capabilities in the upstream stage of the value chain, but not in the downstream. So one would expect that their respective CHIPS Acts would only address their vulnerabilities in the downstream sector of the supply chain. Then my last question looks into whether their particular approach to the semiconductor value chain can be linked to their geo-economic objectives, which has already been mentioned in the room previously, whether on the EU side was on the de-risking and the US on decoupling. So firstly, to answer the first and second question, I've already provided some core findings from my initial legal analysis, which takes a really GVC lens in the textual analysis of these respective CHIPS Acts. So, as already hinted, both instruments show this whole of supply chain approach in their respective instruments, covering literally key nodes of the semiconductor value chain end to end, not just their capabilities or vulnerabilities. This is despite the fact that they have disparate funding structures and capabilities. For example, the US uses a more market-based approach. For example, the issuance of tax credits, really leveraging upon its deep capital market to reshore key domestic capabilities, but also reinvest in its vulnerabilities. The EU uses, for example, existing funding structures, like, for example, the Horizon project, but approaches also the issue of funding through a public-private lens. This is seen in key legal provisions in the EU CHIPS Act pertaining to investment facilitation, for example, simplifying the administrative process of permitting and so on. But both CHIPS Acts do show how they aim to protect their existing capabilities through an economic security lens. For example, the EU CHIPS Act incorporates Article 4 of the FDI screening mechanism. The US's CHIPS Act has this 10-year outbound investment ban, meaning that if you are a recipient of these public grants, you are basically you are banned from actually engaging in transactions with particular jurisdictions the US has classed as entities of concern. So that already answers the first research questions 1 and 2, but how about the last question? We've already established that there's this whole of supply chain approach in these respective instruments, but can they be linked to these geo-economic objectives of de-risking and decoupling? Well, recently in Global Value Chain Scholarship, they have kind of reoriented the Global Value Chain framework in light of the present securitized environment by focusing in particular their attention to state interventions and their implications, especially from a firm level perspective. This is seen in the inside out and outside in approach, which shows both state interventions from advanced and emerging economies. As my case study is only focused on the EU-US, which are advanced economies, my framework of this GVC integrated approach is quite different, but still aligns with the main methodological framework and approach. So if we look at the inside out, what kind of measures do they institute domestically which could be linked to these geo-economic objectives? For example, in line of the EU's own de-risking strategy, it utilizes its public financing models, plus the inbound investment screening in order to reshore key upstream capabilities, but also reinvest in its strategic vulnerabilities when it comes to fabrication. On the US, in continuance of its goal of decoupling critical sectors from countries it deems as entities of concern, utilizes these market-based financing structures together with federal support structures in order to consolidate US capabilities in upstream part of the sector, while also localizing its downstream stages of the global semiconductor value chain. This is seen, for example, the immense financial instruments that have been issued that encourage, for example, the utilization of US steel or North American steel in the key infrastructures surrounding the semiconductor value chain fabrication process. Now, let's look at whether there could be linkages made between this domestic geoeconomic strategy with how these states engage externally. Well, if we look first at the EU, we see a continuance of this de-risking strategy guiding its international cooperation efforts. This is in part also influenced by the mentions of strategic autonomy, which already has been mentioned by my learned colleague here, which has been mentioned throughout key policy documentation surrounding the adoption and after the adoption of the EU CHIPS Act to be a key core geoeconomic objective, mainly, for example, to rebalance dependencies in the global value chain. So you see that language of union strategic autonomy very visible in how they design, for example, these trade and technology councils with the US and India, and of course its recent MOU with Japan. In the US, on the other hand, in continuance of the strategy of decoupling, there's been a clear legislative reordering of its main foreign trade instruments, for example, this classification of entities of concern, because subsequent executive orders the adoption of the US CHIPS Act and after really have classified China, North Korea and others as systemic rivals. So in continuance of that strategy, you see, for example, the establishment of this outbound investment rule, especially within the CHIPS Act, but also in connection to consolidating the strategy in expanded export control regime to really maintain the US's technological edge when it comes to advanced semiconductor value chains. Semiconductors, especially in its application, especially as we are amid the twin tech transitions, whether in AI and of course green energy production. So just to conclude, in essence, the case study and this integrated law GVC approach really has demonstrated the heuristic value it could provide for trade law scholars. In that, it really expands our analytical toolkit in order to situate the contextual factors that are shaping state intervention in critical GVCs, providing a real solid basis for us to explore the legal implications from a trade law perspective, something which I think is missing in the current discourse, because even recent WTO panel disputes do hint at the fact that something is missing in our analytical toolkit to really understand how and why states are increasingly utilizing their position along these key critical value chains and how they design these unilateral trade-related measures. Something which has already been discussed recently, for example, in the US IRA panel report, which came out in January 2026, but also previously as well. There was a dispute called US-China certain tariff measures, which also delved into this issue of overcapacity and the fact that increasingly the US is using these unilateral trade measures to protect its own domestic capabilities, especially through a supply chain mindset. So we really see this tension between the traditional market access obligations as enshrined within WTO legal architecture, and of course how the fact that there's a lack of consensus on how to address the inherent vulnerabilities that come with value-added trade, especially in the present geo-economic climate. So it is my hope that this research sparks new discussions within trade law scholarship on how we could enrich our analytical toolkit that truly confronts the reality of the present GVC world and helps us, maybe, possibly, to rethink our approach when it comes to WTO compliance, but possibly also WTO reform in this new GVC reality. I'll stop there, and I welcome your questions in the later discussions. Thank you.
Thank you very much for your presentation. The last speaker of this panel will be Dr. Rafael Palermo, and he's a non-tenured assistant professor in EU law at the University of Padua in Italy. And he obtained his PhD in law from the University of Würzburg in a joint supervision with the University of Padua as well. His research interests mostly include state aid and competition law, as well as EU legislation on environmental protection and the circular economy. Here, the floor is yours.
Thank you very much, and above all, thank you very much to the organizers for this opportunity and for the organization of this very nice conference. So today I will focus on the raw materials policy of the European Union, and in particular on the Critical Raw Materials Act and whose shortcomings. We all are aware of the relevance of raw materials for the green and digital transition, and above all for the digital economic system. So we can say that the race also to extraction and processing in the entire world produced that the raw materials or the features of criticality, this label has become an integral part of the definition. The growth, the increasing growth for demand of raw materials and their crucial role in the transition, as I said, to a sustainable and economic system which is heavily dependent on them. So we have a high dependence which is surrounded also by, or which produce a very high risk of supply, since we have, by high dependence, we can have also interruptions or bottlenecks in supply chains. Just if we think about some export restrictions or export bans that China has imposed on certain raw materials for that are important for also the Chinese digital and economic system. And the Joint Research Center of the European Commission, in particular the Raw Materials Information Systems, provided in 2023 a map with the major EU suppliers of raw materials according to their level of governance. And we can say that the worse the level of governance is, including also, for example, human rights protection or accountability, political stability. So the worse the level of governance is, so more probable, and the higher, the riskier is also the supply of raw materials. So this is a problem, a challenge for the economic system, for the European economic system, in a phase, so in a time frame of transition to a digital and green internal market. And that's why in 2024, the European Commission, or in 2023, the European Commission proposed the first legislative act, the Critical Raw Materials Act, which was then adopted through the ordinary legislative procedure in 2024, and is the first legislative attempt of the European Union in the field of raw materials, which tries to ensure the functioning of the internal market in these sectors. And the impact assessment accompanying the Critical Raw Materials Act proposal states that only a legislative action is necessary or is appropriate in order to face, in order to build up the Europeans' capacity of strengthening and diversifying the supply of critical raw materials. So the legal basis is Article 114, and the main objective is, we can say, to mitigate the risk of fragmentation of the internal market, so scattered action from member states. But relying on Article 114 reveals also the importance and the relevance of the strategic autonomy, which is embedded, in my opinion, also in the recent regulations and the recent legislative acts, for example, Industrial Accelerator Act, Net Zero Industry Economy, which relied on Article 114 and which are characterized by this, the objective, we can say, to guide the common external action of the European Union and to compel at the same time the European Union to rethink how it acts internally. So we can say that the primary law provisions serves both the internal and the external dimension of the Critical Raw Materials Act, since the functioning of the internal market in this sector can only be guaranteed insofar as the Union's external action in forging, for example, strategic partnerships with third country to create resilient supply chains is uniformly regulated within the Critical Raw Materials sector. So we have in Article 114 and then also transposed in the enacting terms of the Critical Raw Materials sector, we have not only the criticality dimension, so high dependence and high risk of supply, but we have also a strategic dimension. And this strategic dimension is, as I said, was transposed also in the Critical Raw Materials Act, since the Critical Raw Materials Act provides for a criticality assessment, but also a strategicity assessment. So we have not only critical raw material sector, but critical raw materials, but we have also strategic raw materials that has to be intended as a subgroup, so a subcategories of critical raw materials that are characterized by their strategic importance in the green and digital transitions, as well as in the aerospace and defense sectors, by the expected growth in demand and by the associated difficulty in increasing their production. So, in my opinion, relying on Article 114 reveals also the intention of the legislator and of the co-legislators to frame a form of strategic autonomy that not only seeks to free itself by curbing and progressively reducing a high degree of economic openness to third countries, so a strategic autonomy from, but also a strategic autonomy through. So a strategic autonomy that seeks to be built by strengthening the capacity of a political and legal community as the European Union to establish an appropriate and effective regulatory framework. This, a lot of the provision of the critical raw materials sector concerns in particular and are boosted by the strategic projects. So strategic projects is a label that the European Commission twice a year confer to certain projects that apply in the sector of extraction, processing and recycling. And we have some also free benchmarks, in particular a benchmark for extraction, so 10% of annual consumption must be extracted in the European Union, 40% for processing and 25% for recycling. And I will then focus at the end of my presentation on recycling. Nevertheless, the critical raw material sector presents a high degree or a certain degree of inconsistency insofar as it is not adequately supported by a comprehensive governance systems which take into account the multi-level nature. For example, we have to consider that special and land use planning decisions are taken at local, regional and national level and not a European level. So we have this multi-level governance regarding, for example, streamlining of the administrative procedure that is not taken too much into consideration in the critical raw material sector, since there are just deadlines, but they not consider also the difference of extraction, processing and recycling procedures. And the inconsistency, or we can say the weaknesses of the critical raw material sector are, in my opinion, emphasized by the adoption in December 2025, so just 1 year and a half after the adoption after the entry into force of the critical raw material sector, of the Resource EU Action Plan. The action plan is just a soft law instrument, so it produces some legal effects, but it's not binding. And it was adopted at a time when it was not yet possible to fully assess the effects and of the implementation of the critical raw material sector. And curious is also that the shortcomings and inconsistencies highlighted in the Resource EU Action Plan, and later, as we will see in the special report of the European Court of Auditors, these shortcomings and these inconsistencies reflect those inconsistencies that the European Commission already listed in the impact assessment of the critical raw material sector. So 2 years before the adoption of the Resource EU Action Plan. So, for example, difficulty in accessing finance, the lack of targets in EU waste legislation for the recovery of critical raw materials, unpredictable and fragmented permitting procedure. So, the focus of the Resource EU Action Plan is to operationalize the critical raw material sector. And the Commission commits itself to establish the Critical Raw Materials Center, but this confers a higher degree of complexity in the system, since the Critical Raw Materials Act established already a Critical Raw Materials Board, so it's not clear how these two, the center and the board, are working together, or are their work is coordinated, and from who. The European Commission says in the action plan we are adopting in 2026 a legislative act that will in particular so provide and keep this center with tools, so a further legislative act. But then the action plan also mentioned the proposal of the Advanced Materials Act, so a further regulation, and it's not clear if this Advanced Materials Act will repeal the Critical Raw Materials Act, or just amend some parts of it, or just focus on other sectors. So we have this problem of effectiveness and inconsistency, which was also underlined and emphasized by the European Court of Auditors. In particular, the European Court of Auditors criticized in February 2026, within the special report, the fact that the benchmarks that I mentioned at the beginning, so 10, 40, and 25, are only deemed for the strategic raw materials, but not for the critical raw materials. And at the same time, these benchmarks are based on aggregate data and not on granular data. So they just focus on the entirety of strategic raw materials and not of specific individual raw materials or a specific group of raw materials, for example, strategic raw materials for aerospace or for defense objectives. So the problem is that this aggregate data, this very general benchmark, don't allow for an effective assessment of progress in extraction, processing, and recycling capabilities. And this is shown also by my, so I'm going to conclude, by my second last slide regarding circularity and resource efficiency, which is one of the main objectives of the Critical Raw Materials Act. The European Commission committed itself in Article 26 of the Critical Raw Materials Act to adopt a delegated act specifying stream waste products, components, and stream waste containing critical raw materials. But this delegated act was not adopted by the deadline in May 2025, but just 1 year later. And this produced like a chain reaction, since also national circularity plans that member states have to issue for specify in their waste policy which products, which components, and which waste streams are of relevance for the recovery of critical raw materials. Also, these national plans are then delayed. So there is a problem of coordination, but also a problem itself in the European Commission to adopt a delegated act, which, for example, this delegated act, which is very important and influence the entire chapter of the Critical Raw Materials Act concerning circularity and resource efficiency. And also what we see, and this is also part of my conclusion, is that the benchmarks focus only until 2030. So we don't know what the European Commission or what the European Union is going to, or which efforts the European Union is going to have after 2030. Maybe is worth noting that it would be important to create a progressive system, like, for example, in the climate legislation for the reduction of emissions, in order to see we have this benchmark by 2030, but by 2035 we have further benchmark, and then by 2040, in order to coordinate better the efforts at national level and the European Union level. And then maybe some solution will be expected also at the end of this year by the Circular Economy Act, which maybe or we hope, this is a further regulation, but we hope that it will be a boost on circularity, so, and in particular on recyclability and recovery of critical raw materials in the waste stream. So just give a coordination, better coordination in the entire EU waste policy. Thank you very much for your attention.
Thank you very much as well. And now we are looking forward for the comment by Professor Dr. Romy Klimke. She holds a chair for public law at the BSP Business and Law School in Berlin and completed a deputy professorship at the chair for public international law, EU law, and international relations at the Technical University in Dresden. And her research mostly focuses on human rights protection, international public law, EU law, and sustainability law. So the floor is yours.
Yes, thank you very much, Anna, and thank you, Robert, for first of all inviting me to this excellent conference and for giving me the opportunity to present some comments on these really highly thought-provoking papers that I was allowed to engage with, which are really excellently written and cover very topical issues, but are also very different in terms of research topics. So I've decided to use my comment to provide a very general overview on our topic at hand, which is trade aspects of the digital era, and trying to link the specific questions raised to this bigger picture in order to establish a common ground for our further discussion. So I would first like to start by taking a step back in order to gain a broader perspective. So basically, we can travel back to the 1990s. Since then, the face of global trade has changed dramatically, as we all know. There are, of course, several reasons for this: the end of the Cold War, the birth of the World Trade Organization in 1995, as well as the emergence of global value chains. But the most significant new dimension of international trade in the 21st century is how much of it is digital. The digitalization of trade is by no means confined to the sector of information and communication technology. Far beyond the ICT sector, digital trade has become a defining feature in manufacturing, agriculture, mining, finance, and much more. Now, the presentation of our three panelists provide excellent examples of this magnitude of the digital transformation, which generally affects every sector and every stage of global trade. The digitalization of trade not only changes what we trade, but also how and where trade takes place and who trades. Now, to participate in digital trade, it does not need a big firm based in New York, Berlin, or London anymore. Rather, every small or micro business owner, freelancer, or hobby inventor can take part in digital trade. It does not need more than a smartphone to benefit from the digital economy. In a recent count, over 360 million people around the globe participate in e-commerce. So just as a figure, side note. Now, digital innovations have transformed the world so rapidly, as we know, over the past few decades, that decision makers at all levels are struggling to keep up. Despite all of these profound trade-altering developments, there are no specific multilateral rules for digital trade. There's not even one recognized and generally accepted definition worldwide on digital trade. So this is the reason why, meanwhile, intergovernmental or governmental digital regulation is taking place with varying objectives and at different paces, primarily at the national and regional level. And the starting question for any legislator is how much to regulate and to what end. And in my opinion, the importance of finding the answers to these questions cannot be overstated. Without a doubt, the digitalization of trade comes with a lot of opportunities, but there are also enormous challenges and risks. Law and policy makers, therefore, are confronted with a broad range of issues that extend from questions of digital inclusion and connectivity to the regulation of new technologies such as artificial intelligence, to the protection of human rights in the digital sphere, and much more. For instance, and now I come to the first presentation by Lino Munaretto, who has highlighted the tensions of the digitalization of the euro with the right to freely conduct business pursuant to Article 16 of the European Union's Charter of Fundamental Rights. Here, first point, while I found your analysis generally clear and well structured, I was wondering whether you could provide some further explanation how this conflict between the digital euro and private businesses would manifest in practice, simply to make your argument more accessible for readers and discussants who are not as familiar with issues of monetary and financial law, just as myself. At the same time, Lino has very rightly pointed out how the EU's current move towards introducing the digital euro illustrates how the European Union tries to defend its sovereignty in the digital sphere, which in the area of digital capital flows and payment is increasingly dominated by private US American payment service providers, which find themselves in a quasi-state-like position to grant or restrict access and participation. And of course, this raises major questions of power relations and power struggles. Then there's the challenge of providing for and maintaining the necessary technical infrastructure. The digital transformation fundamentally depends upon access to and the availability of critical raw materials. Smartphones, laptops, and countless other devices have to be manufactured and transported, undersea cables have to be laid, and data centers built. And in this regard, Raffaele Palermo has highlighted the crucial role of raw materials and how, I quote, "The transition to a green and digital economic system has exacerbated the race to supply and, in particular, to extraction and processing of these materials." The primary instrument to address these challenges in the European Union is, of course, the Critical Raw Materials Act, with a main focus on the internal market, which is why it is based on Article 114 of the Treaty of the functioning of the European Union. But this instrument is complemented by a growing network of partnerships with third countries that the European Union has forged as part of its so-called raw materials diplomacy. So I have one recommendation to Raffaele. You have highlighted several points that, in your opinion, constitute shortcomings of the Critical Raw Materials Act, which are certainly very valid. And I would be interested in whether you could also present some solutions or improvements in terms of constructive critical scholarship. So you indicated, for instance, that it could be necessary to implement a progressive system after the 2030s or from 2030 on. So perhaps you have some specific proposals that you could also add to your paper. But it's not only critical raw materials that the European Union depends upon, but also certain manufactured technological components, especially semiconductors. So to secure a steady and undisrupted supply of semiconductors, it is of the utmost importance, but becomes more and more difficult in an era of what Esther Osalenlen-Adu has termed the so-called techno-economic competition. As I've one comment on your paper, which I generally really enjoyed and liked, and I also agree with you that we as legal scholars should critically analyze unilateral acts, such as the CHIP Act, as any unilateralism always carries risks in international relations. However, I was wondering to what extent the framing of the CHIP Act as supply chain regulation is really useful, and what can be gained from this perspective, from this kind of categorization, because from my view, there's supply chain regulation in the strict sense, like the corporate sustainability due diligence directive or the European deforestation regulation, which is conceptualized around some kind of system of due diligence obligations. And there might be other regulatory tools that you, of course, may also label as supply chain regulation, but then I would like to know what the actual difference is. And last but not least, I have a question to all three of you that basically pertains to the role of the European Union as a global standard setter. So if we look at the global regulatory framework in the area of digital markets and digital trade, the European Union as a regulator finds itself in a situation of global competition especially with the United States and China. And in this situation of regulatory competition, the European Union has traditionally, at least this is how I conceive it, pursued a regulatory approach that is based on values and fundamental rights, of course, while at the same time trying to preserve its sovereignty. And this approach not only offers an alternative to state-centered approaches of authoritarian regimes, but also conflicts with the position of the United States, which generally intervene very little in terms of regulation. So against this background, my last question would be, to what extent do you regard the instruments that you have analyzed first as a coherent continuation of the EU's digital policies, and second, as a potential blueprint for other state legislators? And of course, we can also pose this question vice versa, and by asking to what extent can these legal instruments aggravate existing geopolitical tensions and conflicts? So, in order to keep my comment brief, I will come to an end here, and I look forward to our discussion. Thank you very much for your attention.
Thank you, Romy, very much for your comment. So, is there any first question or other comment from the audience, or would someone of you like to reply? Okay, Robert.
Well, thanks to all three of you. Really like the insights from this internal market, external perspective. And this is where my question is going to actually all three of you. First of all, since we have three different instruments to kind of tie this internal, external sphere together, if you perceive there being like an overarching approach or strategy behind that, or is just coping with individual problems one at a time? And the other question that regards this internal-external connection is on how this may have a drawback, a positive drawback on security policy, on the sort of supranationalization of security policy in the long run. I mean, this is kind of looking into the glass globe, but maybe you have an idea on how this internal market policy with this external component may affect security policy in the long run.
Thank you. Either of you?
Should we start?
Yeah, of course, if you would like to.
Okay. Or if you want to, up to you. Okay. Okay. First of all, thank you very much for the comments. So I appreciate it, and also for the question, Robert. So first I would start with the comments. Yes, so I underlined, I emphasized more critical aspects of the critical raw material sector, so more shortcomings. I focus more on those aspects, since I wanted also to understand how, for example, the special report of the European Court of Auditors, and then an action of the European Commission through the Resource EU Action Plan influenced or can influence the implementation of the critical raw materials act, even and above all if we consider that some inconsistencies remain unsolved since they are mentioned in the impact assessment of the critical raw materials act, and then they remain unsolved since maybe the critical raw material act lacks of some it's a little bit, in my opinion, in some enacting terms, it's a little bit shallow, so a little bit sloppy and not that targeted. And that's why I think that we need for the future this maybe a progressive system, as I proposed, for example, on the model of the effort sharing directive in the climate legislation. So we can specify clear objectives for groups, for example, of strategic raw materials or critical raw materials. So so based on reliable data, not just aggregate data, all strategic raw materials 25%, since we have aluminium and copper, and there is a very good level of recycling. But then if you consider gallium or tungsten, there is recycling just 1%. So we don't want to balance and just have 25%, but then there are some strategic raw materials that need more recycling, higher recycling quota. So I think that a progressive system could help, and could help also for predictability of investors. Okay, we have this objective for these raw materials regarding extraction, for example, and this must be, compatible also with the current capacity of the European Union to boost on extraction or on processing or on recycling. And secondly, I think we need on the field of recycling and resource efficiency, we need more input from above all, the Waste Framework Directive. So we have, for example, an end of waste concept. So it's a little bit technical, but the end of waste concept, there is just a definition, but then the end of waste is very different for the member states. So each member state has a different end of waste concept, which produce also that the mostly rich critical raw materials, waste streams rich and critical raw materials and strategic raw materials are shipped abroad. The first attempt will be, or entry into force some days ago with the waste shipment regulation, and the European Union classified as hazardous some waste streams, and this so it bans the export to not OSCE countries. So it's like a limitation of the export, so we can, so these waste streams and this waste rich and critical raw materials remains in the European Union and can be recycled here. So I think we have two progressive objectives, first of all, as the fourth proposal, I think, and then second, we have to focus on what we already have. We don't need further regulation or further legislative acts like Advanced Material Acts or Industrial Acceleration Acts. We have to focus on what we have, and we have, for example, eco-design of sustainable products regulation. We have battery regulation, so we have to coordinate and to make compatible all these objectives and all targets that are also enshrined in this regulation. And then so I try to answer your question and also the question of Professor Klimke about continuation or blueprints of the regulatory approach of the European Union. I will focus mostly now on critical raw material sector. We have, and it was for me interesting also analyzing it, we have some provision in critical raw material sector that considers, for example, when strategic projects, since we have to consider that most part of strategic projects are settled abroad, so in third countries, these strategic projects shall be run only after also rights, for example, of indigenous people were considered. So there is a specific provision emphasizing and addressing this aspect. But then we have again this problem. So by signing strategic partnerships with third countries, these provisions remains ineffective, or is up then to the third countries, to implement and to apply these provisions, so regarding, for example, indigenous people or resettlement of indigenous people. So I think the critical raw material sector is a good legislative act insofar as it removed this base on this problem. So it focuses on the problem and it focuses on this regulatory approach. It's a typical regulatory approach, but it lacks of consistency if we consider then the effectiveness of some of its provisions. So I hope I answered your question. And as regarding the overarching approach and this supranationalization of security policies, I was also, I'm not sure if what is better, so if overarching approach, I think now also considering strategic autonomy, as I mentioned, Article 114, that is legal basis for Net Zero Industry Act, for Industrial Accelerator Act, for other legislative acts that were adopted according, for example, Competitiveness Compass and Clean Industrial Deal. So we are following an overarching approach. But I repeat again, underline again, which is in this field, in my opinion, it lacks of coordination insofar as we have legislative acts for specific problems like critical raw materials or building up clean technologies capacities and so on. But then we, by adopting these acts, it seems to me that we forget a little bit the overarching approach, so this general approach. So we forget a little bit what we did a few months ago, or what with the European Union, said, or what it adopted some years ago. So this strategy is a little bit blurred, and then we have a double problem, since if we have a blurred strategy, we are not able or fully able to focus also on specific problems and on specific challenges like those of critical raw materials. And so we need a resource use action plan. So we need another communication. But why we need this communication? It was not enough. So the critical raw materials sector, a regulation is it's very important legislative. It's not a directive, it's a regulation. So we would have better shaped the regulation, or we can also amend the regulation. We don't need, in my opinion, another communication in which the European Union commits itself to adopt other legislative acts. So. And as regards security policies, and then I finish, sorry, I think the importance of this security and also defense policy is underlined, and I think it's a very good point of the critical raw material sector. So we don't have only critical materials, we have also strategic materials that rely on a different calculation method. And this calculation method considers also the difficulty in supply, the increasing growth, and considers the relevance for the economy, and in particular the relevance for defense and aerospace sectors. And for me, it is also, or I interpret it in this way, that the European Union tried to mitigate some challenges, and then to mitigate some problems that could undermine security considerations. So consideration not only of economic security but also of defense. So for example through procurement. So in this way, to specify and individuate some strategic raw materials allow us to boost also on the aspect of security policy in the internal markets, and also in the defense sector, for example, through a double use, so conceiving a double use of strategic raw materials or products. That is also very important, not only materials but also products that are important or relevant for the security policy. Thank you very much.
So just to answer the professor's question, and also cited by Professor. I'm just going to try to attempt to answer the question systematically through two main overarching themes. So first of all, to address the question on the saliency of my framing of unilateral supply chain instruments, well, it's intrinsically linked to an overarching framework surrounding supply chain unilateralism, which is derived from basically my literature reading into value chain scholarship, which centrally focuses on power dynamics. For example, value chain scholars throughout previous frameworks and current frameworks have always stressed how, in essence, their research kind of reveals how firms leverage their existing capabilities, not just market share, but also technical know-how and other capabilities in how they shape value chain creation, who can participate in value chains, and who can be rejected. So in essence, it is a discipline that really tangibly uncovers power dynamics in global trade and production. Now, let's apply that then to state interventions in supply chain in these critical GVCs, because there is a normative element that can be easily classed as a regulatory measure. For example, the CSDDs, the other due diligence and corporate sustainable frameworks. Many have said, oh, these are just regulatory instruments to try to tackle overseas corporate activities, which I agree to an extent. But if you are one of the largest markets in the world in a particular sector, or you have one of the largest and deepest supply capital markets, consumer markets, have a very sophisticated institutional framework, these cannot be treated as simply domestic instruments. They will have an outside impact beyond your prescriptive jurisdiction. But again, as they reflect already existing norms, for example, in the area of business and human rights, or even environmental protection, I can foresee definitely a conversation under the TBT that these are permissible. But then on the other side of the coin, you have the fact that these very particular national regulators at these markets are now increasingly utilizing their market position and existing capabilities in order to attain domestic interests, even though they know it will have an outside impact. As I already highlighted in my research into the global semiconductor value chain, these are highly concentrated in a specific number of markets. So whatever a national regulator does at that particular junction will have an immense adverse impact regardless on even downstream industrial consumers and end users. That requires a legitimate further conversation, especially at the WTO, in order to discipline that exercise. Because now traditionally countries, for example the US, will immediately say that these are national security matters that cannot be addressed. For example, that was the justification of the US after it appealed into the void its recent decision of the January report into the Inflation Reduction Act. So I do hope that my classification of supply chain instrument really triggers a further debate within trade law scholarship, where we have to increasingly take into account the contextual factors surrounding how these instruments were designed. But overall, I do see that the current trend of supply chain unilateralism, which is something I'm further developing in my research, to be now part of the status quo. For example, the fact that there are immense, there's an immense public discourse now on deglobalization, for example, how regional organizations will be much more important when it comes to foreign trade policy and so forth. I think that supply chain interventions will become part of the status quo. It may not necessarily be entirely disciplined within WTO, but I do hope that as we discuss reform matters of the institution, that we do provide a degree of discipline. Do we approach, for example, a sector-specific approach? For example, this was the outcome surrounding the 20-year case around Airbus and Boeing. Maybe something similar should happen when it comes to the semiconductor and steel and critical minerals, because these are the backbones of the current concurrent twin transitions in tech and green energy production. But overall, even though within trade law scholarship we haven't truly grappled with this GVC reality, it is already part of the policy lexicon. For example, after the recent ban on Anthropoc's latest model, which happened, I think, this week. The immediate responses, especially in discourse, was like, well, they cannot do without a market. It was not the language of values on data protection that came later, but it was the fact that how can you exclude one of the largest consumer markets in the world? So even already in the policy lexicon, they are already, the language of power, as seen in value chain scholarship, is already part and parcel of policy discussions. So I think that it's time that we trade scholars also grapple with this, which is already shaping trade law practice concurrently. So I'll leave my remarks there.
Thank you very much. I'd like to focus on Professor Klimke's comment, which was very useful because it gives me the opportunity to give some further explanations on my thoughts on the tension and the conflict between public power and market power, between the issuance of the digital euro and the interest of market actors fearing to lose some of their economic freedom. I think it's a common aspect that was brought up in many contributions at this conference, and that of course the efforts of states to strengthen and to bolster strategic autonomy, security, they all come at a cost. They all bring up a conflict between in the relationship between state and market. But what I'd like to specify that I don't see that as a zero-sum game in a way that only because in the case of the digital euro, the ECB is issuing the digital euro, that does not mean that the ECB is only its power is only growing and the market is losing authority and possibilities to offer its products. I think it's more complicated. So the ECB rightfully argues also that the market may benefit from the issuance of the digital euro because also for reasons of strategic autonomy for the economy, its redundant payment system can be very useful if systems like Visa or MasterCard would be cut off. But what I also like to explain or show and demonstrate in my paper and my presentation is that I think we have to look at the economic constitution and the monetary constitution in specific of EU primary law to see whether there's a kind of boundaries and limits to shifting power from markets to the state. And I think there's some leeway to go in this direction, but also some limits. And I think it's important that we discuss it because at least for the digital euro, I can say there are many voices raised by in scholarship, but also by political parties that see a real chance to transform the whole system. So right-wing parties and left-wing parties, they see digital money as a big chance to overthrow the whole system. And others fear that this could happen. And I think that we as legal scholars and public law scholars have a responsibility to show how balanced solutions can be found. And I think that the legal design, the current legal design as it is intended, as it is proposed by the legislator, is maybe very conservative, but it's also a balanced solution that tries to balance and recognize both the public interest in securing strategic autonomy and safeguarding monetary sovereignty, but also it's recognizing that the market is the place where innovation can take place, where also financial innovation can take place. And we will have to see where this journey ends, but I'm sure that this conflict will come up in many different cases as well.
Thank you. Any other questions or comments? Yes.
Thank you. My question to Raffaele. Thank you so much for a presentation. I think I found it's very insightful. But actually, I find your analysis quite balanced, where you actually acknowledge the importance of CRMA, but at the same time, you explain about the implementation weakness. And through your presentation, I heard about, you emphasize a lot about the circularity and also, recycling. But because I wonder whether, do you think you placing too much reliance on circularity given the limitation of physical of recycling and also circularity, demand of new technology? Do you think you can rely on this circularity and recycling in the face of new technology? And do you think like it's a good strategy rely on those circularity and also recycling? Because substitution is not quite there yet. We haven't we haven't got into creating new technology with new substitution, and lots of the countries actually not ready. Let's say nuclear energy, some countries actually reject the idea. But do you think circularity and recycling of raw materials, it's a good idea to creating this autonomy regarding the critical raw materials? Thank you.
Thank you.
Thank you very much for your question. Yes, so first of all, I want just to underline, also to highlight that we are not able, so we cannot expect to rely only on recycling. So we have also to extract, we have to process, and we have to import. So recycling is not the solution for this challenge. Just to retain the waste streams or retain products with critical raw materials or strategic raw materials, recycle it, since also the demand grows. So there are different quotas. I think, nevertheless, my opinion is that it's a good idea to rely on recycling as a part of the strategy. So recycling what we are able to recycle, building up a capacity for recycling, for example, scrap and other materials. There is a debate on lithium, since a lot of scientists, so the battery regulation, for example, states that by 2031 batteries shall have 80% of recovered lithium content. But then scientists say the recovered lithium is not as efficient as pure lithium, so lithium from extraction, for example. So I think we don't have to focus only on recycling. The solution, or a possible solution, where also a connection between science and law possible is also to boost on, in view of the new technologies, also on substitution. So substitution, I think, is a good point. Substitution is not addressed by the Critical Raw Materials Act, is not addressed by the Resource EU Action Plan, so it's just an initial phase, but substitution maybe could be part of this new act that the European Commission wants to adopt, so Advanced Materials Act or Industrial Accelerator Act. So try to create or try to rethink that, for example, permanent magnets that are useful for wind turbines could be replaced, and we have actually technically and economically feasible technologies that could replace, in some cases, permanent magnets, and with other kind of technology. So we focus on, I think recycling is important for certain, and that's why I highlighted, okay, we have to divide the waste. We are just not to consider strategic raw materials as a group. We have to consider the specific strategic raw materials or a group of strategic raw materials, and then we are able also to say, okay, we have substitution, we have replacement opportunities for this, but not for these other raw materials. And then we can we have to implement our capacity of import, for example, for third countries, for those strategic raw materials, or to create new technology and then to substitute and to create substitution and replacement materials. Thank you.
Thank you. I think there was one more question, and I think, then we should slowly come to it.
All right, then I try to keep it brief. I have a mix of questions and small comments. Also, maybe I'm then a bit embarrassed because I don't know so much about like banking and stuff to ask a very simple question, but I was just wondering how the digital euro, or is it logical, I don't know, could play a role in creating a financial union, because like, I mean, in digital sphere, that's what's named often, especially also being a global standard setter, like that capital flows are just hampered, and I don't know, can you redo the system with that somehow? And I know the problem is normally the taxes, but can you maybe harmonize it on this digital euro sphere to create new investment methods to foster innovation? I know that those are really, generic sense I just said, but maybe in that direction, and you say no, that does not make sense at all, then I'm also fine with the answer. To Esther, I just want to say that it's a really cool perspective, looking at the nodes of the supply chain and like how to steer them, and that just gave me a lot of thought that I will take home, but I don't have a fixed question there. And then kind of a comment and a question, but also maybe it's to all of you, but mostly I guess to Raffaele, because I was thinking, I mean, researching on the Brussels effect, the EU as a global standard center, and then generally, I mean, I guess it's now with the geoeconomic turn, the US is forcing others, China is forcing others, the EU is trying to not let it look like it, but it also goes in a way. And then before it was things are convincing or things are economically sound for other countries or companies to take over these standards, and now they're also really uneconomic aspects other countries follow, especially the US. And probably it's mostly about increasing the benefits for especially the smaller countries, maybe combine or make like raw material deals, like you get ours, we get yours, and also combine the channels. And regarding the channels of externalizing influence, also was regarding the Brussels effect, that the question would be and the easiest way to create a de facto and then maybe de jure Brussels effect, have product focused regulations. I was just wondering how many product focused regulations are, for example, in the Raw Materials Act. Is there, for example, explicit regulation on how to recycle products in the Raw Materials Act, and so to detract, because like this regulation, you could, like if companies have to create products that they have to be recyclable in this way, or raw materials have to be extractable, they would have to do it probably for the whole world, and maybe then you can also attach other normative things like values and all that sense. So this is more to Raffaele, but actually to anyone who likes to answer. Thank you very much.
Yes, thanks for your question. Maybe first as kind of a further explanation, because I I didn't expect that everyone here has heard so much about the digital euro and its regulation. So the legal design of the digital euro as it is proposed in the digital euro regulation, which is still negotiated at the time at the European Parliament, it provides that the digital euro has a very limited use. So it shall mainly function as an alternative to cash, and practically also to an alternative to other payment methods that are used in everyday transactions, like in the supermarket or online for buying stuff there for normal customers. So, for instance, there will be this holding limit that I addressed, and this will prevent that any end user can hold more than a certain amount of digital euro in his wallet. So this feature is supposed to protect financial stability. It is meant to prevent these effects, these displacement effects and the disintermediation of the financial system. So from a political or economic perspective, you might criticize this approach as too cautious or too conservative and not using the potential of digital money. But for that reasons, I think also those scenarios that you have addressed are not probable that they will be realized. But in legal scholarships, there are also there are some interesting contributions on this topic that also address the potential of digital central bank money from a legal critical point of view, like Katharina Pistor or Robert Hockett. They imagine a scenario, a future system of money that is more public and more democratical, and they see digital central bank money as a possible tool to implement such system. So that's, but this is more a theoretical debate that is not taking place in the political sphere so far. I mean, there are some contributions and some from I think the lefts in the European Parliament. They published a paper on a more public digital euro, but I think they won't be successful with this approach. And also from the right-wing parties, they from the other side raised concerns about too much state control, and they fear, or they express this fear, that the state can and the central bank could gain too much power by and I think the middle way that they now pursue, and in the majority and the US legislation, that is the approach to find a balanced solution, but a careful solution that is not triggering too much disruption in the system.
Regarding your question that you gave kind of to all three of us about whether the EU can remain a standard setter, at the end of the day, it is still down to economics. Yes, the EU has this sophisticated institutional structure, large consumer base, somewhat disparate but also deep capital markets, whether here in Germany and so forth. But at the end of the day, the economic case still has to be there. So, for example, recently China released its own supply chain a framework which basically stated to its companies that if you choose to abide by some of these supply chain instruments in corporate due diligence and so forth, it could potentially be in contravention of our own domestic law. So really showing that the choice lies with firms whether they want to continue to comply or they go elsewhere, which they can increasingly now do, because as you know, some of the key centers of economic commerce and development are not only solely in Europe, but also increasingly in Southeast Asia and of course North America. So so the case for Brussels to remain a key normative actor has to be coupled together with the economic case, ensuring that it continues to grow and develop, because that will be tied to the degree or willingness by which firms will continue to comply with these increasingly stringent standards. However, there is also recent jurisprudence in international economic law that maybe these regional to regional trade arrangements could be an area by which you can balance these kind of standard setting norms of the EU with their own respective domestic interests. For example, the EU-Mercosur agreement is a perfect example of this, where they kind of balance the EU's own climate objectives and goals with the development orientation of the Mercosur states. So there is an emerging practice all around some of these core regional trade agreements that really show that there is a third way by which you can still balance norms, even though you may not necessarily be the core global standard setter. So definitely look into those. Yeah.
Thank you very much. Yes, I think that as Esther also said, the European Union is an important, very important regulator, but this must be also reinforced and supported by economic competitiveness. So that's why I think we are also, we insist on this concept of competitiveness, that maybe is also be a competitiveness obsession. So Paul Krugman in 1994 spoke about competitiveness obsession and anxiety, but above all obsession. I think that so we are as a regulator, we are able also to, we can say, to spread some technology, some requirements. If I refer to the eco-design of sustainable products regulation and a lot of requirements regarding refurbishment, reusability, repairability, and recover of of raw materials and in general of products. I think that it could also influence some technology also in third countries that maybe are supplier of raw materials. And I try to formulate it since and I think it's not like an idea that cannot be implemented, since, for example, in the field of hydrogen, we have now I refer to more to competition related issues, but in the field of hydrogen, we have some Commission's decision authorizing state aid for hydrogen plants settled in third countries, and the condition for the authorization, or one of the conditions for the authorization, is not only compatibility with the internal market, so Article 107, but it's also the fact that in that third country a supply chain, so a value chain for hydrogen is also established, so that this attempt to gain hydrogen for the European Union, so for the internal market from third countries, but also have a beneficial aspect and beneficial effects also for that third country. I think there is also an attempt in the Critical Raw Materials Act, so there is the idea to implement it and then to create, to export, so to regulate, but also to create like a technical and regulatory framework also abroad, but at this standards of the state of art, some strategic partnerships with third countries, also small third countries, are not working that well as expected in the Critical Raw Materials Act. This is also one of the critics that are shortcomings that are addressed in the special report of the European Court of Auditors, since the European Court of Auditors highlights that the European Commission is not able to provide so the outcomes, the effects, so the results of these strategic partnerships nowadays, so which effects effectively these strategic partners are producing for the internal market and for the third country. So the focus is the third country. I think it's very important, and we cannot forget it or just neglect it.
Thank you very much. I think for the sake of timing, it would be quite good to move the further discussion to lunch. So basically I would say we are done actually with this year's YELS conference. First of all, or before we all go to lunch, let me and also Robert say a few final remarks and words. First of all, obviously, thank you to everyone who participated, who spoke, and who engaged in discussions, and also obviously all the organizing stuff and who supported us. And so now our further program is basically that we'll go to the university cafeteria, which is like a 5-minute walk from here. Everyone is obviously invited to join us. Afterwards, we will do our city tour, which will start in front of our conference venue here at 2 p.m. In case you decide not to come to lunch, you can meet us here at around 2 p.m. And otherwise, you can just follow along. And then one more quick note, please collect all your name tags in front of the room because we need to give them back. I think that's it from my side.
All right, just a quick addition. For lunch, you need those 2 vouchers that you have in your map. We have enough vouchers for guests as well. So from my side, I've been awfully quiet yesterday and today. So thank you all for coming, thank you all for contributing, thank you for all the help, thank you for the comments and so on and so forth. But there's one more thing I want to put as a thought. This is a self-organized conference that started traveling Europe. Started out in Austria a couple of years ago and now travels the continent. And this conference only takes place if there is someone taking over the job. So if any of you may find that interesting to host a conference like this at your university or with some friends at a partner university, please feel free to decide to do that next year for the 10th edition. Just approach us for any comments, for any help, for any organizational stuff. We're happy to help out and give some insights. And we're looking forward for the 10th edition next year somewhere else. So thank you all for coming and enjoy lunch.